held that the rent receipts of Joydev Mondal are not relevant to the issue involved, and any observation in the or with regard to those rent receipts will not affect any proceeding between the plaintiff and Joydev Mondal. এই দিলীপ, এটা একটু কালকের ফাইনাল ড্রাফটের সঙ্গে কম্পেয়ার করে দেখতে বসো। তুমি এটা দেখে নিতে
এইটা
next. Yes. Next.
I appear for the petitioner, madam.
What is
appear for
this?
the opposite party wife.
This matter is the arising of matrimonial proceeding. This matter went for mediation. Mediation was successful, my lord. Terms were parties came into terms, my lord. That was
The
yeah.
last occasion, Lordship, the matter was adjourned because the amount, if your Lordship will kindly come to the agreement.
1 minute.
Yes.
I will not adjudicate that. Let
No,
the
no, no,
trial
no,
court
nothing, nothing.
adjudicate it.
It has been agreed, Lordship, that the 5 lakh of rupees, the husband will be paying for the tuition fees of the daughter. Now, on the last occasion, that amount was not secured with the receiver, or he's acting as a receiver, Lordship. Now,
Who is the petitioner?
he is the petitioner, husband is the petitioner.
Okay.
Now, the learned advocate for the petitioner will be holding that amount of 5 lakhs as a receiver. As and when the amount is required by the institution, he will hand over the checks. Now, I understand that an account has been created in the name of the husband only, and the amount is there. But I do not know whether he has got the amount or not.
The account has been created in HDFC High Court branch, my lord, where the 5 lakh amount has been there, my lord. Checks have been with me held by my lord. If they wishes,
Nothing. This is revision is over now. Let the trial court decide everything. Take down. Peruse the final report of mediation and the original terms of settlement dated June 21, 2023, submitted by learned advocate mediator, High Court at Calcutta. The mediation was initiated by an order dated March 22, 2023, passed by a coordinate bench. In view of the terms of agreement, nothing remains to be decided in the revisional application. The the report of mediation along with the original terms, as also the settlement of agreement, be sent down by the department to the court of the learned additional district judge, fast track, 4th court, Barakpur district, 24 Parganas now north, before whom the matrimonial suit number 1024 of 2017 is pending. The learned court is directed to proceed in accordance with law on the basis of the settlement agreement arrived at by the parties and pass necessary orders. In view of the fact that parties have agreed for a dissolution of marriage on certain terms and conditions, which are self-explanatory as per the report of the learned mediator. Original ta jabe kintu ei ঠিক আছে।
Grateful to you, Lord.
Next. Disposed of.
My lord, I am appearing on behalf of the petitioner, my lord.
আচ্ছা, ওটাতে আর্জেন্ট ফটোস্ট্যাট কপিটা দেবেন অর্ডারটা। আর্জেন্ট ফটোস্ট্যাট সার্টিফাইড কপি। সার্ভার কপিটা থাকবে কিন্তু এটাও থাকবে। হ্যাঁ, নেক্সট।
My lord, I am appearing on behalf of the petitioner. Defendant.
Mr. Pal, I have to release this matter
Lordship.
because I have a relative of mine is involved in this petitioner Akra, released on personal grounds.
That's fine.
Next.
My lord, I am petitioner for some correction.
Yes, what is the
Order
correction?
Order para number 4,
1 minute,
Yes,
1
it-
minute. Yes,
they are stated title shoot order injunction was pending. No injunction there, petition was pending. I stated
what
paragraph
petition
14,
was pending?
title shoot.
You did not even know your case that day. You were not even able to answer any query of the court. You said, I categorically asked you at least 5 times, what are the applications pending? And you had said that application for temporary injunction was pending.
No, my lord.
No,
My senior,
your senior did not appear that day, madam.
yes, my lord, Mr. Rafiqul Islam.
It was there. His name has been given later on. I remember very clearly. What is the, which part you want correction?
Second, fourth para. No injunction order passed there. Injunction application was pending there. I stated petition para number 14.
What are you saying? Which matter is this? It's a writ petition. What is the correction you want? Please call your senior. বলে এখন তারপরে চেঞ্জ করে দেবে গল্প। এই যে এখানে না।
Well, stated 14 number.
In the second line of the 4th paragraph, of the order dated so and so, and an order of injunction passed in title suit number subsistence, and the sentence and an order of injunction passed and in place of in third line, ing as follows করে দিই। তাহলে আমরা নিজেরাই কারেকশনটা ওখানে পড়ে দিই। এখানটা হবে petitioner alleges that during the corrected sentence portion shall read as follows. The petitioner alleges that during the substance of the civil suit, the title suit number 781 of 2017, corrected portion. Next.
I am for the petitioner, my lord.
What is the correction?
My lord, the suit is pending, this case is pending before the landed district judge, my lord. My lord, but it has been recorded that civil judge junior division first court Berhampur. Certified copy was issued by that court, my lord. But the suit is actually pending before the landed district judge.
What is the valuation that suit will be pending before? What is the suit?
It's a arranging out a partition suit, my lord. This miscase has been filed.
Huh?
Miscase has been filed, my lord, arranging out a partition suit, my lord. Still pending before the landed district judge, my lord.
Look at your type copy, what you have done. Come back at the back, civil judge senior division, civil judge senior division.
Issued
Orders have been passed by the civil judge senior division. As per your type copy. How am I supposed to know where it is pending?
before the district, landed district, my lord.
Huh?
Landed district judge, my lord. My mistake on my part, my lord. Perhaps I, my lord. failed to point at before lordship.
But I don't understand why. ঠিক আছে। এই নাও। The last line of the first paragraph order dated so and so. Next civil judge jurisdiction first court Berampur Murshidabad be corrected as district judge Murshidabad. Next district judge. Yes.
And but the last paragraph of the first page.
Similar correction be also incorporated in the
Last paragraph of first page, my lord. The revision application disposed of with the direction upon the.
the second and third line of the last paragraph in the first page of the order.
Great.
My lord, I am appearing on behalf of the petitioner, my lord. The mistakes appear in the order, my lord, mainly attributed to my wrong submission. Now, my lord, save and accept one. My lord, in the first paragraph, my lord, the spelling Alipur subject to correction, my lord, needs to be corrected. Third line of the first paragraph.
The third line of paragraph 1,
Now, my lord, the
Alipur be corrected as ALIP4.
last line of the second paragraph, Lanet District Judge, my lord, Howrah. This is pending before the Lanet District Judge, Howrah.
Last line of the second paragraph,
My lord,
comma, Lanet district judge Howrah be incorporated.
my lord. Second page, my lord, fourth line. Now, my lord, this is entirely wrong submission of my part, which was subsequently withdrawn, maybe deleted. This is still pending consideration. My lord, an application for enhancement of maintenance pendentility has been filed by the wife, and that is still pending adjudication. My lord, which was subsequently withdrawn. My lord, fourth line.
The third line of the second page of the order shall end with the expression wife. The expression which was subsequently not instituted.
Filed by the wife. My lord, an application for enhancement of maintenance pendentility has been filed by the wife. My lord.
It's the final order.
My lord, the final order.
All applications.
Yes, within this.
Items, but I beg to appear on behalf of the blood petition. Blood extension of interim order.
Service.
Blood upon in their presence, blood the date was fixed. Blood they are appearing on many occasions. They appeared. Blood. And blood in their presence, blood the another honorable coordinate bench, blood the fix the matter for hearing also. Blood.
What is the matter for?
Blood the matter is this. I was the blood the defendant tenant. Blood the blood 3 application was disposed of against me. Blood that is not the case of the landlord, that I was the defaulter. 712 application was decided holding that there is no default so far as the 712 is concerned. Subsequently 73 application was filed. Blood the 73 application irregular payment. Instead of blood the depositing the rent in court, I deposited in the controller with the controller. Now this is the question whether this is it is the in technical sense I am the defaulter, whether in real sense I am the defaulter or not.
You are, because court has said, Supreme Court has said that has to be interpreted as it is.
Lord, I will also place certain judgment, Lord, before your lordship, Lord. In the Supreme Court also held, Lord, the Khemka judgment, Lord, in technical sense, defense cannot be struck out.
Khemka has now been overruled by the subsequent Chamaria judgment.
Lord, our high courts also, Lord, they passed the several judgment. Lord, kindly see Madhavi Mukherjee's case, Lord. There also the same things has happened. And Lord, I am also placing, Lord, one more judgment, our high court's judgment, Lord, where the review application was held at same fact. the matter deposit was made with the controller instead of the court.
So was this point raised by you in the 7-2?
7-2 was decided in my favor. The 7-2 learned judge has held there is no default. Kindly see the
Depositing with the controller before the disposal of 7-2 or after?
before that.
And you continue to deposit?
Continuing that, yes. Kindly see the order impugned, everything has been recorded by the learned.
Extended. Monthly list of September.
Grateful.
The matter actually in the month of September as a motion. 30th November. None appears on behalf of the opposite party. Fresh notice be issued upon the opposite party, as also the learned advocate appearing on behalf of the opposite party. So, how many opposite parties are there?
Only one blood.
One opposite party. On the opposite parties. Affidavit of service to be filed on the next day. Monthly list of September as an upgraded motion.
Grateful.
Next.
Blood, next blood, I am for the petitioner. Blood, so far as the service is concerned, blood, I served twice, 2 affidavit service are on record. That was recorded by order dated 15 September 2022. Blood, even including the advocate on record on the trial court, I served. Blood, I was the plaintiff petitioners. Blood, this is the suit for eviction. Kindly see, blood, the order impugned, order number 30. Blood, I prayed for amendment of certain typographical mistake. That was rejected. Kindly see, Lord, page 30 impugned order and the proposed amendment. Proposed amendment is page 35. Lord, my should state, Lord. All these are figure, my Lord.
What is the stage of the suit?
Lord, the issues has not been framed, Lord.
All right, service upon the opposite party. Learned advocate. Now, despite service on 2 occasions, none appeared on behalf of the opposite party. Special service upon the opposite party. How many opposite parties?
Lord, only one.
And also the learned advocate appeared on it. Let this matter appear as a urgent motion as the first item on 17th. Okay, service.
Yes, I can.
How will you do the opposite party?
Opposite party, I will send it by the speed post tomorrow.
24th July as an urgent motion.
24th. Grateful. Lord, the interim order, if any.
Interim order extended up to 30th September.
Grateful.
Here, that is none appears on the next day.
Yes.
Right, please, Lord.
I am for the opposite.
Lord, I am appearing on behalf of the petition this matter, Lord. Lord, your Lordship, may kindly see the order dated, the first order which has been passed by this court, Lord, on 20th of May 2022.
What is the order?
Lord, my Lord, I have come up against, Lord, the dismissal of my application under Order 47 Rule 1 and Lord Order 6 Rule 17. Lord, the matter was moved before my Lord.
Order 47 Rule 1.
Yes, and Order 6 Rule 17, my Lord. My Lord, Lordship, we kindly see the order dated 20th May 2022 for a moment.
Yes, what is your, where is the decree?
Lord, Lordship, may kindly.
What is your
Lord,
submission in
my
Order 47? Where is your Order 47?
Lord,
Section 47.
Order 47 application that was directed.
My lord, section 47
Yes,
petition, I have annexed, my lord, in page 4.
yes.
You are the
Opposite party.
Says
Yes,
the
my lord.
opposite party, my lord,
I have
all
annexed
affidavits have
it, my
been
lord.
complete, my lord.
I have annexed it in my petition, my lord, in my opposition, my lord, page 47, 14. my lord.
Opposition.
Please take your seat.
Yes. Page 14, your lordship. Yes.
Yes, what is your case?
Which my humble submission before your lordship is this, my lord, that the decree which she has obtained, my lord, it has been obtained in a fraudulent manner. For the reason I am saying fraudulent in the sense, your lordship will kindly turn to my lord's, her affidavit in opposition, page 2.
Who is the petitioner? Who is the plaintiff?
My lord, I am
Plaintiff
the plaintiff.
is she, yes,
Part.
she is the plaintiff, and relationship brother and sister, brother and sister. But it is alleged that the father of the plaintiff executed a deed of gift in her favor. That deed of gift was challenged. Matter went on, my lord, for a long time. My lord, my client lost. My lord, then application under 47 rule 1 and for amendment. Yes, yes. Appeal was preferred, your lordship. I'm coming to that. My lord, thereafter, my lord, my lord, the appeal was dismissed. The appeal was dismissed. Second appeal, my lord, possible, my lord, that was also dismissed. To be very candid with your lordship, my lord, when the decree came to for execution, my lord, it was found that when she has made an she has made a statement in her deposition that her name has been, my lord, mutated in the Calcutta Corporation record. It is not a fact. Your lordship will kindly, my lord, see for a moment the copy of the affidavit in opposition which they has filed.
Decree, suit.
Copy of the plaintiff
Plaint, I want to see the suit. The judgment in the suit.
judgment in the suit. And the judge suit.
One point for your
Yes.
non-execution is that her name has not been muted.
Never. Your lordship kindly turn for a moment. My lord, lordship will kindly see for a moment the affidavit in opposition filed by her before this court. For a moment, your lordship will kindly see how far, my lord, the falsity can go. Your lordship will kindly see page 2. My lord,
One minute. Please show me the judgment. Why is the decree not executable according to you?
my lord, the decree is not executable for the reason, my lord, there is total suppression of fact. And by suppression of fact, my lord, the decree has been obtained fraudulently. My lord, so a fraudulent decree cannot be executed.
What is
Your
the
lordship, for it,
fraud? That is the fraud.
my lord, her name has not been mutated. She has all along stated. Lordship, kindly see for a moment for my set page 2, my lord, paragraph 3, subparagraph, my lord, of that. Her affidavit in opposition. When the things have been disclosed before the honorable court, when there was direction for filing affidavit, the dispute between, yes.
These affidavit in oppositions are not required in a civil division where everything is a matter of record.
My lord, may I humbly,
Statement here doesn't count. If the court found that she has a right to evict you, that she is an owner on the basis of the deed of gift. And
that
the
deed of gift,
addition-
that deed of gift has never been, my lord, I am putting this question to myself.
Yes.
The deed has gift has never been acted upon. Lordship will kindly, my lord. No, I tell you, my lord, the deed of gift has, the deed of gift has never been acted upon, and on the basis of the deed of gift has name, your lordship kindly note down, my lord.
So title suit number
Yes.
178 of 2006 is pending.
My lord,
The second
Yes,
second suit filed by them is, my lord,
Pending.
I have come to know from the reply, my lord. And that is also on the same cause of action, my lord. And the first suit, first suit filed by them has already been dismissed, and this is the second suit.
Lord,
And
I'm
this is
putting
the
this,
second
Lord,
application, yes.
Lord, I'm putting this question to myself, subject to lots of clarification. Lord, I'm putting this question to myself. My lord, a deed of gift has been executed, very well. On the basis of this alleged deed of gift, my lord, a suit has been filed for eviction of the licensee, not as a tenant, as a licensee brother. The matter went on. The fact was never revealed. The true fact was never revealed. In her deposition also, she said that, for a moment. Yes.
Why is the decree not executable?
My lord, I'm putting this.
You have been
My lord, I'm putting
unsuccessful.
this question to myself, my lord. My lord, lordship kindly. My lord, on the basis of the alleged deed of gift which has never been acted upon, my lord, a suit has been filed for eviction of the license.
That was disbelieved
let
by
me-
the court.
Huh.
No, I will not allow you to procrastinate this argument
My lord,
because this is on merit of the decree, which you have been unsuccessful in the suit and in the title appeal. You have not gone beyond that and filed a second appeal. In section 47, you cannot say that the decree was not acted upon.
My lord, may I humbly submit, subject to lordship's correction. Lordship will kindly, for a moment, for my satisfaction, lordship will kindly see page 2 of her affidavit in opposition. For a moment. For a moment, your lordship
Just
kindly
read
see.
it out, read it
My
out.
lord, the dispute between the parties, it is her estate, has arisen when the opposite party have acquired the said property by virtue of a registered deed dated 5th of September 86, executed and registered by Satish Chandra Paul in favor of Malina Mandal, her client, the opposite party here. And after acquiring the said property in the aforesaid manner, the opposite party mutated her name in the official record of KMC and mutated her name in the office of the jail RO and paid land rent up to date. This is totally false. If lordship kindly see, Lord, my reply to the honorable. Lordship will kindly see for a moment. We have made an inquiry from the Calcutta Municipal Corporation. Our reply page E, annexary page 80. Your lordship kindly see for a moment. Truth, lordship, I say, any amount of factual aspects will never be
Where is your written statement?
written statement copy. Lordship kindly see.
I have to annex your written statement.
May produce the written statement. I have got the copy, but it is not with it. Next, sir, E for a moment, lordship kindly see page 80.
Please
If
give me
truth
your
cannot
written
be,
statement.
I tell you, any
Please give
amount
me
of
your written
assets,
statement.
any amount of assets cannot hide the truth. This is the judicial, judicial
Give me your written statement.
written statement.
And where
That
is
is-
the
yes.
judgment?
Oh,
That is the only thing you have to rely on. You have not brought that.
But
How
I,
can you file a opposition without seeing the judgment of the suit,
but I
which you
don't
are
have-
trying for execution?
Calcutta
Where
Municipal-
is the judgment? Show me the judgment.
Copy of judgment. Lord, it is a suit of.
my lord, this is the second application under section 47. My lord.
All right, I will give you an that cannot be the only ground, madam. You have
I'm
to be
sorry,
ready
ma'am.
with your
Copy
case.
that, sir.
Please sit down.
Lord, lordship takes up
No,
tomorrow.
I will take it now. Please bring the give the
Judgment
judgment.
copy. No, you can judgment to learn. Just let me see. Lordship kindly give me a minute's time. Good for licensee. Shooter copy to judgment to depositions to reduce the deposition. Missed case judgment. Title suit judgment copy to. Missed case. ना 2020 सूट ना आगे कर सकते हैं, जेटा आगे कर सकते हैं। যে প্রথম শুটটা হয়েছিল তার জাজমেন্ট কপিটা দাও। এই আপনার কাছে আছে নাকি? আপনার কাছে কি? প্রথম যে শুটটা ফাইল হয়েছে তার জাজমেন্টের কপিটা আছে? আমার কাছে তো নেই ওইটা। না না ওইটা প্রথম শুট জজ সাহেব যেটা জিজ্ঞেস করছে তার উত্তরটা দিন, উল্টো পাল্টা বলবেন। যেখানে ও বলেছে কি আমার নামটা মিউটেড হয়ে গেছে। দেখো তোমার কাছে আছে?
Yes, your first point is that her name was not mutated. Second
but-
point,
Milord, and that I-45 from the information which I received from the Calcutta Municipal Corporation. That is there, Milord, that I have annexed also. Your Lordship will kindly see.
yes, all right, next point.
Lord, that is my point, that a decree, even if it has been obtained, Milord, on the basis of her deposition, the deposition itself is false. She has made a false deposition before Milord, in the witness box, that yes, my name has been mutated, and on the basis of that, I have filed the suit. That is not the fact, Milord. Lordship will kindly appreciate. Milord, a plaintiff files a suit on the basis of a false deposition, that my name has already been mutated on the basis of the deed of gift which has been executed in my favor. Still, the corporation tax bills comes in the name of her late father or our late father. Still, up till 2023. And on the basis of false statements, he files a suit against her brother as if he is a licensee, and a decree has been obtained. The truth must prevail, my lord.
Truth
The
prevails in
purpose of Lord,
not execution.
no, my lord, your lordship will kindly appreciate. At any stage of the proceedings, if a truth is revealed with your lordship, that this is the falsity which has been committed by a party, your lordship has every right, my lord, under the inherent power.
In
That
this
yes.
application under section 47, where have you mentioned that the decree was obtained by fraud and the decree was passed only on the ground that a mutation had been taken?
Actually, that was not at that time in our knowledge. Lordship, my lord, at that time, it was not within our knowledge.
How many applications he has filed?
My lord,
Section 47, show me.
My lord, two applications, my lord. First application, this is the second application, and first was, my lord, 33 of the, my lord, it found space in the order impugned also, my lord.
Yes, take down. The revisional application has been filed against an order dated April 8, 2022, passed by the learned civil judge, Unit Division 5th Court at Aripur, District 24, Parganas, in Miss Case number 83 of 2017, arising out of title execution case number 5 of 2004. Miss Case number 47 of 83 of 2014 is an application under section 47 of the Code of Civil Procedure. The petitioner contended that the decree could not be executed and the title execution case number 5 of 2004 should be dismissed on the ground that the deed of gift dated September 5, 1986, executed by the father of the plaintiff and the defendant, had not been acted upon. That the fact that the defendant was allowed to continue to reside in the premises as a licensee was also not correct. In the plaint, the date of grant of such leave and license in favor of the defendant allegedly by the plaintiff had not been mentioned. The fact that other defendants, other persons were also residing in the said premises has also not been had not been disclosed. Just the evidence of PW1 was not enough for decree of this for passing a decree in the suit for eviction and recovery of khas possession, eviction of a licensee and recovery of khas possession. With regard to the execution of the deed of gift, the plaintiff did not adduce satisfactory evidence. Both the plaintiff and defendant are heirs of late Satish Chandra Pal, were heirs of Satish Chandra Pal, and the relationship between the two was required to be determined before the decree of eviction was passed. The petitioner also wanted to incorporate certain facts by way of an amendment in the miscase number 83 of 2017. The learned court below rejected the miscase number 83 of 2017 along with the application for amendment, inter alia holding that
ডিপোজিশনে বলেছে কি মানে আমার নামটা মিউটেড হয়েছে, অথচ নামটা কিছু মিউটেড হয়নি ডিডব্লিউ বেসিস করে। হ্যাঁ,
that an earlier application under section 47 of the Code of Civil Procedure, being miscase number 33 of 2005, was filed by the petitioner. In terms of under order 21 rule 97 2 TO2 101, read with section 47 of the Code of Civil Procedure for re-adjudication of certain disputes. Again 47 to deben na. In the said miscase, upon perusal of the entire evidence adduced by both the parties and the exhibits, the learned court was pleased to dismiss the miscase, negating the allegation of the judgment debtor. That the petitioner as a plaintiff also filed title suit number 178 of 2006 for declaration and injunction. But the suit upon contested hearing was dismissed with cost. The present miscase was instituted on the self-same grounds which were already rejected by the executing court while disposing of miscase number 33 of 2005. By an amendment, the plaintiff, the petitioner wanted to introduce a new case with regard to execution of a will, which was not a part of either the written statement filed in the title suit or in the title suit, what is the number of this title suit?
My lord, which title suit lordship is referring to, my lord?
151 of 1992.
151 of 1992, nor in the subsequent suit filed by the judgment debtor. The court found that the decree had attained finality in 1993. And since then, the decree holder has not been able to enjoy the fruits of the decree. The application under section 47 was a futile attempt by the judgment debtor to delay the execution proceeding of the decree holder.
And order 6 rule 17 is also there, my lord.
The court found that such frivolous application should not be allowed, as it would encourage
CPC.
recalcitrant litigants to perpetuate a litigation endlessly. The application was dismissed, as it was specifically found that the said application was a classic example of gross violation, abuse of the process of court. Next paragraph. Mr. Ray, learned advocate for the petitioner, submits that the decree was obtained by fraud,
My lord.
as the petitioner had not mutated her name in the records of Calcutta Municipal Corporation, although she had claimed so.
My lord, subject to losses.
On such ground alone, the decree will be a nullity, as fraud vitiates all.
My lord, for a moment, may I interrupt, subject to losses pleasure. My lord, lordship may kindly refer to page 80 annexure E of my my lord, reply. That will suffice. Whether I lose or win, that is another matter. But your lordship will kindly refer to that.
Reliance has been placed
Annexure E, page 80.
on the property tax bill
Annexure E, page 80, my lord.
of
My query. Query that has
the
been replied.
premises in respect of which the plaintiff claimed to be an owner by virtue of a deed of gift from the father. Page 83 and
Page 80, my lord, my query has been replied. by
further
the-
reliance has been placed on the allegation,
Page 80,
on the such contention,
Annexure E, page 80.
referring to an answer by the Calcutta Municipal Corporation
Yes.
with regard under the Right to Information Act as to who was the recorded owner. According to the petitioner, the recorded owner continued to be the late father.
Let that be quoted, my lord, if your lordship subject to lordship's pleasure. Let that be quoted, because they say very clearly that premises in question meaning.
Doesn't change anything, sir.
Yes,
It has been
for my satisfaction, let it be
mentioned
quoted,
that
yes.
the property tax was paid in the name of the recorded owner, Sri Satish Chandra Paul.
Yes.
It appears from the plaint filed in the title suit that
That is দাদা যেখানে বলেছে কি আমি recorded owner আছি. My name has been muted, she has said so falsely. She has made a wrong statement. It is a perjury. Is a clear case of perjury.
Where is your plane?
Plaintiff is annexed with the reply.
Yeah. Just, Lordship, kindly give some.
That I have it. That Satish Chandra Paul, the original owner by a registered deed of gift dated September 5, 1986, had bestowed the property upon the petitioner, had gifted the property upon the petitioner, upon the opposite party, and the opposite party became an owner thereof. The defendant is the full brother of the opposite party, who was allowed to reside in respect of 2 rooms with a common veranda, bath, and privy. Schedule, which was Schedule B of the plaint, or the property to Schedule A of the plaint. That the plaintiff was finding extreme hardship due to paucity of accommodation, and hence the suit was filed for a decree of recovery of khas possession upon eviction of the defendant as a licensee.
In plaint also says that my name has been mutated.
The petitioner filed a written statement and raised the points with disputed the correctness of the genuineness of the deed of gift. It was the specific case of the defense that the deed of gift had been obtained by fraud, misrepresentation, and had not been acted upon. That the father was paralyzed for 8 to 9 years, and taking advantage of the physical and mental illness of the father, the sister had obtained such deed of gift. That the sister had not recorded her name, mutated her name in the office of in the records of the corporation.
Much obliged, Lordship.
But the name of the father continued in the records of the corporation. On contested hearing, the suit was dismissed. Decreed. The petitioner filed an appeal. The petitioner was also unsuccessful in the appeal. There is nothing on record to show that the petitioner had not approached the higher forum, being aggrieved by the judgment and decree passed in the title appeal. The mutation case of the petitioner, being Miss Case number 33 of 2023, arising also out of the self-same decree. Now, arising filed in a proceeding arising out of the for execution arising out of the self-same decree. The mutation. No. The Miss Case number 33. Title suit number 965 of 2022, which was filed by the petitioner. 965 for declaration of title and permanent injunction in respect of the self-same property, being title suit number 178 of 2006, was dismissed on contest. It appears that a probate proceeding is pending in respect of the property in question. Earlier, Miss Case number 33 of 2020. Where is that?
33.
Where is that you have said in this?
Yes, my lord. I have annexed the application, my lord.
Page
14, my lord.
কি বললাম? 14 of
14 my opposition, my lord, of my opposition.
All right.
I'm sorry.
Earlier, Miss Case number 33 of 2005, arising out of the self-same judgment and decree, which was filed in title execution case number 5 of 2004, was dismissed. The same points as raised by the petitioner was raised therein. And the question of fraud and forgery had been raised. All these questions were negated by the learned executing court upon evidence and upon consideration of all the documents. By the second execution case, second miss case, the petitioner sought to reopen the entire facts once again. The issue of the learned courts below were convinced with regard to the, were satisfied that the plaintiff had been able to prove her title in respect of the suit property and had also arrived at the conclusion that the plaintiff, that the petitioner was no more than a licensee in respect of the property in question. Hence, an order of eviction was passed. Recovery of cast possession upon evicting the licensee was passed. A decree was passed. The sage decree has not been upset by any forum. The contention of the petitioner with regard to the executability of the decree has been negated on evidence upon contested hearing once before. Such decision operates as a res judicata. It is in the subsequent miss case. It is also settled law that the principle of res judicata appears not only to suits but also to between the parties in a same proceeding at interlocutory stages as well. Execution, the ground of forgery of the document, the decree of the questions with regard to forgery of the gift of deed of gift, fraudulent execution of the same through the unwell father, by the unwell father at the instance of the sisters, and the issue of fraud raised have already been negated earlier. There is no scope to reopen the issue. The revisional application, the learned court below rightly rejected the miss case number 83 of 2000. Koto? 2017. Divisional
on the
application is
question of
dismissed. Yes. No.
the urgent certified copy may be given.
Yes, of
Ah,
course.
And I beg your lordship
আর
for history of
কি হবে একটা judgment দিয়ে দেবো।
I beg your lordship for history of the
Next.
operation of this order for 30 days only
Later,
in the
the
interest.
petitioner prays for না তারপর ওখানে লেখো with regard to the probate suit, this court which is allegedly pending, this court is of the view
Yes.
that when parties are contesting the suit, the result of the suit shall be the consequences of the final decision in the suit shall follow. But at this moment, when a decree of 1993 for eviction of a licensee is sought to be executed, and where the petitioner has failed in various attempts to stall such execution of such decree, this court does not find any reason to pass any orders to protect the judgment debtor under the factsum circumstances. Yes.
I was praying for history of operation of this order.
Later, the petitioner prays for stay of the operation of the
15 days,
judgment
Your
and
Lordship.
decree, which is denied, which is considered and rejected.
The urgent certified copy may be given.
Yes, everything you will get. Don't worry. Next.
Lord, I appear on behalf of the opposite party.
My lord, it is
One.
my application, my lord. This affidavit service is there, my lord. My lord, it relates to my lord, the preemption case, my lord. And my lord, one final order was passed. Again, that my revisional application is pending for hearing. My lord, his lordship, the Honorable Justice Sanjeev Banerjee, what lordship then was admitted in the same. And my lord passed an order In the meantime, if the possession is taken by the preemptor, he will not mortgage alienated or otherwise without leave of the court. But during the pendency of the the revisional application, the preemptor make an application for police help without serving any copy to the preemptee
In the execution case.
in the execution case, my lord. And my lord, the learned court below, without hearing me, passed an order of under order 2008 of,
Police help for what?
yes, my lord,
Police help for what?
or they're taking possession of the lands in
So
question.
High Court never said he can't take possession. Take the,
Yes.
you will not get any order.
Well, one thing subject to correction, that application is pending for hearing, my lord.
Mr. Giri,
Yes, my lord.
show me Justice Banerjee's order.
My lord, I have annexed in this matter, my lord.
The execution was not stayed.
Execution was not stay, but
Then
my lord, that time the execution was not there.
maybe
After that execution case started, my lord, very not the one.
why was the copy not served?
But that is for my instruction, but kindly see the orders. How the belief was assaulted, prevented on several occasions. Kindly see the orders it is recorded.
In the application,
From the
kindly see first, my
deposition-
lord, page 25.
From the deposition, it appears while executing the writ in respect of
Where is
judgment
that?
passed in
Where is that?
13.
My lord, kindly see page
Certified
25.
copy order,
My
certified
lord,
copy
kindly
of the
see page
second.
25.
1 minute.
Yes, my lord. Yes, my lord. My lord, the application.
How
which-
old are you? Then please sit down. Yes.
The certified copy, second page, from his deposition, from the deposition of the bailiff, it appears that while executing the writ in respect of the judgment passed in preemption miscase number 13, judgment data gathers several people and used abusive language against the bailiff, and they refused to give delivery of the possession and abide by the decree of the court. They also tried to assault the bailiff, but never disclosed their identity. Accordingly, the bailiff failed to execute the writ in assumption of breach of peace in the area. Therefore, upon perusal of the records and considering the facts of the case, goes into the view that police help will be useful in executing the writ in this case. This court further opines that no person has authority. That is the observations of the court. Now here, without my learned friend is referring to that judgment of the preemption, but I am both way covered. There is one view that if the entire property is sold, then preemption is not maintainable. Another view is that it is maintainable. But I am covered. His case is that the entire property has been sold, but in the decree itself, it is recorded that the entire property has not been sold. So I'm not a
But if- What is the earlier order passed?
the earlier order, that is the earlier order, because of the larger bench, the submission was made by your friend that the issue is pending with the larger bench. That is, but that issue is not affecting my case. I am both way covered.
My lord,
It is
kindly-
recorded in the order itself.
my lord, kindly see page 19. My lord, the order, my lord, I have communicated to the.
May I suggest one thing, Lord? The interim order expired long ago. Lordship hears both the matters. I can satisfy that I am not at all covered, not at all affected.
Justice Banerjee's order, show me.
My lord, kindly see page 19. Page 19, my lord.
19 of?
19 of the revisional application.
19 to nahi kono.
Communications,
19.
communication of in the letterhead.
This communication order, my lord.
Where
Communication.
is, you don't even take the copy.
Yes, I have seen, my lord, but I. Well, kindly see since the principal issue involved in pending consideration in a reference, the present petition is required to be admitted. The matter pertaining to preemption and the issue is whether upon the transfer of the whole of the share of the co-sharer, section 8 of the West Bengal Land Reforms Act 1955 may be attracted. The petitioner will have all paper used in 2 courts below ready so that the same may be looked into the final order, final hearing. The petitioner will also inform the opposite party that the matter will appear as a contested application in the first monthly list of the after puja vacation. Any steps taken by the opposite party will abide by the result of the present 2 proceedings. In the event the opposite party obtain possession of the relevant land, the opposite party will remain restrained from dealing with or disposing or alienating, encumbering same or partnering with the possession of the thereof in favor of a third party without the previous leave of the court. This is the order. During the pendency of that, my lord, the execution case is started and take police help without serving any copy. Well, kindly see page 25. I am reading this. ওদি কিন্তু জোরপূর্বক দখল লইতে গেলে জোরপূর্বক দখল লইতে গেলে, my lord, I being the owner of the property and I have in possession, I have
Thing. Execution, he has a right to contest. And the revisional application order has been passed. In the event that you get possession, you will not do that. But does that take away his right to contest the execution?
No, I am not for a moment, I am not saying
Let
so.
this police help application be reheard.
My lord,
I
my lord, kindly hear both the application, everything will be settled once, because the misapplication.
That it is still pending.
No, no, not pending. My response submission, the submission was even, my learned friend is saying that the entire property has been sold, but the recording of the preempting code, that is not there. So I am both way not affected by the order of the larger bench. I am covered both ways.
that was
This is
challenged
the
before the
wrong
Honorable High
wrong
Court.
submission was-
Wrongly quoted, wrongly
At the
concluded.
time of admission, wrong submission is made, madam. And hear out both the matters.
It's not possible to hear out. What I am on
Alright.
is that even if you file an execution being a decree holder and let us say that nothing is pending in the High Court, even then
He has a right.
he has a right to contest.
Yes, yes.
So
He-
let him
He
contest.
has contested. He has contested, thereafter bailiff went to get the possession.
No, this application for police help.
After the failure of the bailiff to execute the writ.
This order should, this
After-
application should have been served upon him.
Yes, it has been served, but I do
No.
not know why it is saying so, but kindly, there is no recording and there is no submission also that may not be
Yes,
in the, where?
my lord, I have stated in paragraph 19.
Not paragraph. What have you said in, what has happened in the order?
Yes, kindly see.
No, no, in
Where
the order, it
petitioner
is nothing,
said that
nothing.
no
recorded.
application was served upon the petitioner. The order has been obtained ex parte in spite of full knowledge of the order dated 26/7/2018. Without stating that revisional application is pending for hearing and the same is referred to the larger bench and misleading the court will obtain the order. But without whispering any order, sentence in the police cell, they want revisional application is pending before the Honorable High Court in spite of the receipt of the revisional application.
My point is that it is not
Maybe,
for the
but
first time.
there, but
It is
one
not-
thing or the
He was
the police cell
contesting,
is concerned,
he was
I
content,
have some
kind.
right to
He-
object.
It is not that he is the ex parte, he was contesting in the execution case. Bailiff without with notice went to get the possession. He was prevented, he was tried to be assaulted by the unidentified persons arranged by the, the judgment, the judgment debtor. Thereafter, this police order was passed.
And I kindly
The order of the,
Certified copy.
my lord, my lord.
Bring the entire certified copy of
My
the
lord,
police case.
my lord.
Otherwise, if you can agree that he was not hurt, I will ask for.
My
a
lord, my lord,
written
no, he was contesting, my instruction is that. Thereafter, my lord.
Not that. This application.
Yes, I'll take,
The writ
my lord, I'll get the copy of the orders.
interim order extended up to 30.
My lord, kindly hear me, my lord, for a bit.
Under the heading upgraded motion in.
My lord,
August.
kindly fix that matter also along with this, tag this matter, along with that matter. Main matter on merit, kindly tag that. My lord.
That hearing is not possible.
No, no, only, but I am saying that I am not affected by the order of the larger bench.
Monthly list as a
Mother-
upgraded motion.
Kindly bear with it for a minute. But this submission was made that the issue,
Along with CO.
yeah, then
It was
it's
786 of 2018.
786 of
6 of
2000.
2018.
But interim order
In the
extended.
meantime, the petitioner is restrained from changing the negative
Yes, yes,
character
yes.
of the suit property
Yes.
or from creating any third
All
party
right,
interest.
yes,
You will
definitely.
not do it.
Yes, my lord.
Yes, yes.
And my lord, interim order extended up to
আটা কবেকার মামলা সিওটা
No, no, final,
18.
পারবো না, আমার তো 20
final hearing name.
কেটে দাও কেটে
Oh,
দাও
মানে
আমার
determination.
কেটে দিও।
Oh,
Determination.
my lord. My lord, I have no jurisdiction.
The entire certified copy of the pre-execution case shall be produced in order for the court to shall be produced so that the court may ascertain as to whether the application for grant execution of the writ with police help
Yes.
had been served upon the petitioner or not. Yes,
My
next.
lord.
Obligation.
Interim order up to 31st October.
30th September.
হয়ে গেছে। আগের বছর সেপ্টেম্বর থেকে এক বছর পেয়ে গেছে।
Next
Get
item,
I beg to appear on behalf of the petitioner.
opposite party.
Opposite party number
Key.
1 and I'm opposing this extension, lordship.
The plain defendant number 3 and 4 is the petitioner before your lordship. These two person, my lord, is an advocate. My lord, what happened? Plaintiff has, my lord, a transaction between principal defendant number 1 and 2. My lord,
What is the order impugned?
Milord, the
Order
order
7,
impugned
Rule 11
rejecting,
is
Milord, the application under order 7, rule 11, because Milord, myself, Milord, defendant number 3 and 4, these two persons, Milord, acted as a Milord advocate in respect to a transaction which has been taken place between plaintiff and principal defendant number 1 and 2. Milord, the thing, Milord, the allegation is that, Milord, I have drafted, Milord, the deeds and all that. For that, I have siphoned off something, some money, Milord, by misappropriating, rather, Milord, the during the course of action, as I have acted as an advocate, this was my misconduct on my part, and I have, Milord, dodged him, and some money is being siphoned off in favor of the principal defendant number 1 and 2, while acting as an advocate in the entire transaction. In my respectful submission, this particular dispute, Milord, when a comprehensive, Milord, code is being, Milord, made up, Milord, the Advocates Act, this honorable court as well as the honorable Supreme Court said, yes, if you have an allegation with regard to any of the advocate while he was acting as an advocate in the entire transaction, you will have to allege misconduct before a
So the
particular
suit
forum.
is money claim
Yes, damages.
against
And
all of
also
you.
Lord,
declaration also,
yes.
Lordship.
Show me the plain.
Yes.
But Lordship, this is not the case made out in the Order 7,
I shall
Rule
show
11.
for your lordship. Because otherwise, Lord, every advocate has to be, Lord, entangled before every litigation.
Page 11, Lordship, is the plain.
Lord, prayer, your lordship will only get, Lord, page 21. Lord, Roman 5.
1 minute. Advocates Act is with regard to the conduct and the license being cancelled.
And also, Lord, the damages. I will show, Lord, the one of the judgment. Lord,
1
where
minute.
your lordship looking to the plain, Lord, paragraph 5 onwards, kindly looks at. এটা জানবো প্রাইমারি হচ্ছে সেকেন্ডারি হচ্ছে এক্স্যাক্টলি Allegation on.
Yes.
My lord, why, my lord, I will say, my lord, clever drafting, because your lordship has noticed, my lord, the
Show me
plaintiff
the
himself.
Advocates Act.
Yes.
देखिए दाओ
Here, my lord, the plaintiff have himself admitted that my lord, whatever duty I have done during the course of, my lord, the entire transaction as an advocate. And he said that yes, something is being done on my misconduct. He has been divulged and something is being shown to him that the deed has to be valued at such and such to save the registration stamp duty. So entirety, my
Where
lord,
is
the
the
wrong
document?
advice of an advocate at best.
No, he said that all of four have cheated him.
No, my lord, while acting as an advocate, if, my lord, his
You
case
are
is
an
that
advocate, you will claim that.
that is, my lord, the immunity. That immunity is being given, my lord, by the act. My lord, the Honorable Supreme Court has held, even, my lord, under Article 226, if this Honorable Court found that one advocate is being, my lord, acted, my lord, something which is, my lord, derogatory to the interest of the court, even on contempt proceeding, the court cannot punish him. He has to refer the matter to the, my lord, ultimately the Honorable Supreme Court said, he has to refer the matter to the
punishment. Punishment will be the
No, my lord.
Advocates Act.
No, my lord.
What about the money that they have?
I'm coming, my lord. The money, it's not their case that the money is being, my lord, taken by me. Whatever wrong advice I have given, for that, my lord, some benefit is being given to the principal defendant number 1 and 2. So the wrong advice on my part, that is the primary allegation, my lord. This has to be proved first.
No, that is not only wrong advice.
But I shall-
They have said
Yes,
that
yes.
you have
No.
misled them.
Yes, misleading them means, my lord, for the purpose of giving some benefit to the principal defendant. So it's my wrong advice while acting as an advocate. Otherwise, my lord, an advocate who has executed a deed, my lord, or drafted a deed, it has to be by both ends. Then in every litigation, the advocate has to be, my lord, implicated as a party. There is a transaction between plaintiff and the principal defendant number 1 and 2. The money, some money is not being paid by the principal defendant number 1 and 2. Check is being dishonored. I could understand, my lord, that is there. But if I have done something, I have given some wrong advice for which defendant number 1 and 2 is being benefited, then that in the course of my, my lord, acting as an advocate, I have given a wrong advice. That, my lord, forms part of misconduct. That he will have to prove first before the, my lord, the appropriate forum. Thereafter, the question of damages will come. Please,
Who was the buyer?
defendant number 1 and 2, my lord. Huh? Huh?
And what was the issue? You didn't give the money.
I know.
Sale
Lord,
proceeds were not
that
given.
is that no. Defendant number 1 and 2.
Two checks.
There are, Lord, it was assured that entire consideration money will not be paid on the day of execution of the deed. So on that, Lord, assurance, Lord, the plaintiff has executed the deed. But the rest amount of money for which, Lord, the checks was being handed over, that was dishonored. So, Lord, entirety, this transaction is between plaintiff and defendant number 1 and 2.
And
Upon his
Lordship,
good faith,
TDS
he has
amount
executed.
was also not deposited.
That is also not mine.
TDS amount of 57,68,000 because Lordship, these lawyers were doing all the things. They were conducting everything. If
Then,
Lordships comes to my plaint Lordship at paragraph 5 onwards Lordship, I specifically say that the defendant number 1 and 2 advised me to Lordship entrust them. These two advocates, Lordship, the defendants number 2 and 3, because Lordship kindly comes to paragraph 5 at page 13, that after the settlement of the terms, the defendant accompanied the plaintiff, went to his
What is the
advocate.
situation now?
Now,
Lord, I
Lordship,
have been-
my evidence is over. Now that the time has come for them to come to the dock, They have filed an application under Order 7, Rule 11. On what ground? One, that Lordship, I have made
Advocates
the
Act.
mayor a party, but I have not served upon him the statutory notice. And second, that I have filed this suit, a very comprehensive suit. This comprehensive suit is not maintainable. I ought to have filed several suits.
Show me 7, Order 7, Rule 11.
Yes, Lordship, their application
Yes,
is at
Mr.
page
Mukherjee.
26.
Milord, page 25, it
26.
starts.
25, Lordship, it starts at page 26, paragraph 4, that it further appears from the records that the mayor of KMC has been figured as defendant number 5 in the aforesaid suit, and that in the prayer portion.
Paragraph
How is
6.
misconduct of
But
an
paragraph 6, Milord,
is misconduct defined in the act?
section 35, Milord, perhaps, Milord, that is the, Milord, scope of inquiry.
Professional or other misconduct?
Yes.
Yes.
In various, Milord, judgment, Milord, this has been, Milord, now being explained. What is the misconduct about? And what
Yes,
is the
but,
scope of
every
inquiry?
lawyer cannot be immune from every prosecution.
No, Milord, I
because
am not
he is
saying-
a lawyer and
No, Milord,
Advocates Act is there.
No, Advocate Acts, Milord, the entire scope of the Advocates Act. It's a self-contained code. Milord, entirety,
So then
special
every
mechanism.
advocate is
No, Milord,
immune from
I'm
any
not saying- Milord, I'm saying, Milord,
prosecution.
if a person alleges misconduct or wrong advice given by an advocate during the course while he has acted as an advocate, Milord, he has
It is not-
admitted.
They have not said only wrong advice.
Yes.
They have said misled. Yes.
That is, Milord. So, Milord, I have, Milord,
But not,
given
you
some.
are not their advocate that she suffered on account
I
of
am-
her ill advice.
No, Milord, he stated
But their
that on good
advocate.
faith, Milord, the defendant has introduced me and
Yes.
he has also relied upon my advice. So it was his choice. Milord, after execution of all these deeds, he has himself in open eyes. He admitted that yes, rest
Anyway, suit is there only now on the verge of ending. Have you filed your written statement?
Yes.
So let it be contested.
Milord,
Take
but
down.
this issue, Milord, your
That will
lordship,
be the first issue. Suit is already in the evidence stage. I will direct within 1 month.
and one
evidence-
thing, Milord, Milord, may I
Yes.
ask, Milord? Subject to my lord. But since, Milord, as an advocate, I have been now, Milord, the court is directing me, Milord, to appear, to give evidence. Milord, let it be done, Milord, on a commission. Let my evidence at least. Milord, being a professional, Milord, at this age, Milord, he has to come to the dock, Milord, with these allegations. Milord, let it be done, Milord. Otherwise, Milord,
Only সারা জীবনে professional, it will be a problem.
it's looks
But
something.
Lordship, if he is not guilty in open court, it will be proved.
Milord,
That is also there.
In the evidence may not be, yes, take down.
Let them, Lordship, take appropriate application in the
Yes,
court
yes,
below.
yes.
If they want to do it in the commission, Lordship.
Examination and cross-examination both will be.
Let them file Lordship application there in the court
Yes,
below.
yes,
Let
yes,
it be
yes.
considered.
All
there.
right. The revisional application arises out of an order dated October 31, 2022, passed by the learned Civil Judge Senior Division 4th Court at Alipur. By the order impugned, the learned court below rejected an rejected an application under Order 7, Rule 11 of the Code of Civil Procedure. The defendant numbers 3 and 4 prayed for rejection of the plaint on the ground that the said defendants were advocates who were advising the parties with regard to the sale procedure for sale of the property in question, and they did not have any other interest apart from exercising their professional expertise and knowledge in the transaction. According to the said defendants, the Advocates Act 1961 was a complete bar
But Lordship, these points were not
for
taken.
continuation of the suit before the learned court below against the learned advocates who were acting in professional capacity. Reference has been made to section 35 of the Advocates Act 1961. There is no bar provision here to bar a suit.
48, my lord, one is just section 48. Indemnity against legal proceedings. Indemnity against legal proceeding, like 48, section 48.
Further reference has been made to section 48 of the Advocates Act 1961. In this regard. Next paragraph. Ms. Shohini Chakraborty, learned advocate MS, appearing on behalf of the plaintiff, submits that the plaint case alleges misrepresentation of facts by all the defendants, including the defendant numbers 3 and 4, that the defendant numbers 3 and 4 were acting in collusion with the defendant numbers 1 and 2 during the entire course of the transaction. The defendant numbers 3 and 4 also asked the sons and daughter of the plaintiff to be confirming parties to an agreement for sale. That the entire transaction which took place were at the behest of not only the defendant numbers 1 and 2, but all the defendants. Next paragraph. The learned court below rejected the said application on the ground that now, the plaint case was for a decree of declaration that the alleged deed of conveyance, which was executed through the plaintiff by misrepresentation and fraud, be declared as cancelled and revoked. Further decree of recovery of cash possession by evicting the defendants, numbers 1 and 2, was made. Another declaration was prayed for against all the defendants, that the said defendants had obtained rupees 70 lakhs from the plaintiff wrongfully, decree for recovery of damages for defamation against all the defendant numbers 1 to 4 jointly and severally. Why defamation? Ms. Chakraborty, why defamation?
Defamation should not be there. Damages, Lordship.
For damages of it, defamation. Damages against all the defendants jointly and severally amounting to rupees 3 crores. The learned court below rejected the said application on the ground that notice upon the Kolkata Municipal Corporation was not necessary in the facts of the case. As the Calcutta Municipal Corporation did not appear in the before the learned court below, No, was not in the case. As there are no major reliefs claimed against the Kolkata municipal corporations. With regard to the non-maintainability of the suit against the defendant numbers 3 and 4, what was the reason given?
Lordship, they filed this order 7 rule 11 on two lordship grounds. One is that no notice to KMC was given, and another lordship, I have made a comprehensive suit. These two grounds.
And my lord, there
Regarding
was no
lordship KMC notice, it
With
was
regard
held,
to the other prayer for
and that
the other ground for rejection, the
that's
honorable
page
court
7
found
onwards. Lordship,
Lord,
kindly
one
see.
ground was taken, my lord, there was no privity of contract, my lord, between defendant number 3 and 4, and my lord, the plaintiff. My lord.
that the allegation of non-existence of a privity of contract between the defendant number 3 and 4, non-existence of a privity of contract between the defendant numbers 3 and 4, was not a ground for rejection of the plaint without trial on evidence. The other grounds with regard to the nature of the suit and the framing of the suit were also rejected. Having considered the contention of Mr. Mukherjee, this court is of the view that the entire plaint case read as a whole indicates that the plaintiff alleged misrepresentation, fraud, cheating, etc. against all the defendants jointly and severally. The defendant numbers 3 and 4 were not engaged by the plaintiff. It is not the plaint case. It is not the only plaint case. Now, the plaint case is not only based on wrong advice of the learned advocates or the learned advocates engaged, or that the learned advocate engaged by the plaintiff had committed professional misconduct. The plaint case in a nutshell is that when the plaintiff wanted to sell the property to the defendant the defendant numbers 3 and 4 approached in the defendant 1 and 2. 1 and 2 approached the plaintiff. The defendant number 1 and 2 introduced the plaintiff to the defendant numbers 3 and 4. And the plaintiff, being a resident of the UK, trusted the said defendants and entered into the transaction by executing a deed of sale, deed of conveyance. Thereafter, what happened? The money was not paid.
Yes, Lordship. Thereafter, two checks amounting rupees 70 lakhs, Lordship, bounced, and Lordship's
Checks of rupees 70 lakhs issued by the defendant numbers 1 and 2 towards the consideration money bounced.
and Lordship, the TDS, they also did not submit the TDS, Lordship.
That tax deducted, the TDS certificate they were supposed to give you. No?
Yes, did not submit that amounting rupees 57 lakh 68,000.
The amount to rupees 57 lakhs, which was allegedly deducted as tax as TDS, was also not certified.
That would be part consideration. My lord, 2.8 crore was paid.
Towards part certified, and all the defendants together had acted in a collusive manner to deprive the plaintiff of the legitimate consideration money which was agreed upon. Hence, the suit was filed for declaration that the deed of execution conveyance was null and void, for recovery of possession from the defendant numbers 1 and 2, and damages against all the defendants jointly and severally, apart from a decree for recovery of the 70 lakhs which had bounced, which were tendered by way of 2 checks which had bounced. The plaint as a whole does not indicate that the sole allegation against the different numbers 3 and 4 is professional misconduct as contemplated under the Advocates Act. Moreover, the reliefs claimed are not covered by the Advocates Act. Prima facie. Section 35(3) of the Advocates Act provides the orders that may be passed while deciding a complaint with regard to conduct of advocates. Such order does not deal with a decree for recovery of money or for payment of damage or for payment of damages. Secondly,
Section 43 is also there that relates to cost of proceedings. Section 43.
Section 43 of the directs that the Bar Council, the disciplinary committee, the section 43 and 48 of the Advocates Act cannot be pressed into service in this case at this stage, as this court is of the prima facie view that those sections do not deal with the reliefs claimed by the petitioner in the suit. Whether the defendant numbers 3 and 4 acted strictly in professional capacity, and the allegations against the defendant numbers 3 and 4 should be confined to only professional advice as lawyers, is a matter of evidence and trial in the facts of this case and in the pleadings which appear from the plaint. The learned court below did not commit any irregularity in passing the order impugned. The order impugned is not interfered with. The divisional application is dismissed. However, the contention of the petitioners that they may be allowed to adduce evidence through commission in view of the professional interest involved. The petitioners are at liberty to approach the learned court below for consideration of such prayer. We shall be heard upon allowing the plaintiff to contest the said application. Yes. Next. With such prayer, evidence. The evidence may be recorded by way of commission. To adduce evidence on commission, আরেকটা কথা বলে দাও ওখানটায় যে the issue with regard to the maintainability of the suit against the defendant numbers 3 and 4 shall be the first issue in the case amongst the other issues. Issues have been framed, no?
Issues have been framed, my lord.
What this has been issued? Is it this an issue?
Maintainability, I am not sure whether maintainability.
Acha, as it is informed that issues have already been framed, this court directs that in case the issue of maintainability of the suit against the defendant numbers 3 and 4 have not been framed, such issues shall be incorporated in the list of issues. Yes.
And my lord, let a separate application be filed, my lord, for the commission.
I've said that. Yes, next. Shall be decided. First কেটে ওটা ওটা কেটে দাও। ওটাও কেটে দাও, সে ওখানে বলেই দিচ্ছ, ওটা উপরে ওখানটায় দিয়ে দাও। ওখানে লেখো the maintainability of the suit against the defendant number 3 and 4 who allegedly acted as learned as advocates who allegedly acted in their professional capacity shall be framed by the court if not already framed. Yes, next.
My lord, I am for the petitioner. My lord, section 24 application filed by the wife, my lord. The matrimonial suit filed by husband in the,
Service is there.
yes, my lord.
আসবেও না, পরেও না। কোথায়? Where is the suit?
Suit is in Kollani, Nodia.
It's all right. Let this matter appear in the list on July 12th at 1 p.m. One more service be effected upon the notice be you are the wife.
I am the wife petitioner.
A further notice be issued up to the opposite party husband as a last chance.
My lord, fixed it on July 12th. That is tomorrow, my lord.
Oh, sorry. 26th.
Grateful.
Interim order already passed is extended up to 31st July. No, August 31st. 31st August. Opore affidavit of service is taken on record. Despite service, none appears on behalf of the wife, husband. Yes, enough.
Grateful.
Next. 26th মনে রেখো তো ডেট, সেদিন সেকশন 24 গুলো সব মনে কোথাও লিখে রাখো। Yes,
I'm for the petitioner.
Wait 1 minute.
I'm for the petitioner, wife.
Mr.
This is an
Vijay, you are there.
This is an application under section 24 of CPC. The petition.
Where is the service?
The service.
Please give. Affidavit service is taken on record. Despite
But the
service,
track
none appears
report
on-
shows, the track report in page 6, page 3, page 4, sorry, shows that the item is on hold. But one thing, your lordship
Yes,
will.
affidavit of service is taken on record. This court is not satisfied with the service. Fresh service upon the husband. Interim order.
I seek leave, your lordship, I seek leave for the service to the work again of the opposite party as well as to the learned advocate also.
Fresh service of notice upon the learned advocate for the opposite party as also upon the opposite party at his official. Now, office is not right.
Yes,
matrimonial.
he has submitted the affidavit of liabilities. In that he has mentioned his address of work again.
Maybe, but why do we take the matrimonial suit to the office?
He resides at Gujarat.
All right, at his official address at Gujarat.
And the interim order, your lordship.
31st August. Oh, না তাহলে এ তো হবেই না। তাহলে ওটা 24 August করো, 30th September. Yes, 24th August, 30th September. Yes.
Oblige.
At 1. ওগুলো কি বার পড়ছে গো? 24 করো না তাহলে। 23 August করো। 23rd August.
23rd August.
Yes.
Your lordship.
বুধবার করে section 24 ওই 8টা সময় নিয়ে নাও। Yes, all right.
Read for it.
14, my lord, transfer of the acted case. Your lordship knows, my lord, in terms of section 9 of the Guardians and Wards Act, my lord, where the ordinarily child is residing, proceeding has to be initiated in that court. Now, my lord, moreover, in Howrah court, there are 3 proceedings pending where the husband is contesting. And my lord, the act itself.
This is service.
Yes. Sorry, my lord.
ওই একই করো।
But only thing.
এই নাও, নিয়ে নাও।
Kindly keep it because it's very short time. I covered
26th August. Where do they stay?
Howrah. Service.
তার মতোই করে দাও 26
But I will issue a
26 July 1 p.m.
I will issue a notice, my lord.
Despite service, none appears on behalf of the opposite party. Fresh notice be issued upon the opposite party as also the learned advocate appearing on behalf of the opposite party in the Act 8 case. As also in the other proceedings.
Howrah.
Same lawyer.
No, my lord. One is Howrah, one is Parasa.
To our respective learned advocates. As a last chance.
But only thing, my lord, in Barashat, we never appeared because my lord, we then and then file application. In the Howrah, my lord, we can. And moreover, husband has contacted with my junior by over telephone. She informed that the matter has been fixed today, but I will serve notice upon that because
Learned advocate appearing in the in which proceeding? Act 8 proceeding.
Act 8 proceeding, we are not contesting, we are not going there. Now, my lord, in Howrah, my lord, three proceedings pending, 125 DV Act.
In the proceedings pending before the learned, which court?
Before the learned.
The criminal proceedings before proceeding pending in Howrah. Learned advocate representing the husband in all the criminal proceedings pending in Howrah. In all the proceedings pending in Howrah.
Kindly extend
As also upon the opposite party.
Intimate
Totally.
opposite.
Yes, all right.
Intimate text.
31st August. Yes. Fresh notice along with a server copy of this order. আগেরটা তো তাই করে দিও. Yes, next.
I beg to the petitioner.
Yes.
My lord, I am from the opposite party.
এখানে আছে ইন্টার্নটা আছে মেয়েটা নেই না ইন্টার্নটা এই যে আমার ইন্টার্ন আছে Yes. What is this?
Defendant petitioner filed the instant civil revision matter challenging the order dated 3rd August 2022 matter passed by the learned 12th bench of City Civil Court at
What is the
Calcutta.
order?
My lord, order dated 3rd August, my lord, whereby
1 minute, give me 1 second. Should not be. Yes.
my lord, order dated 3rd August passed in a case to application order 9 rule 7, my lord. When the case was fixed for expertise and I made an application
For?
under order 9 rule 7 for set aside the expertise hearing, my lord.
Yes.
My
Well,
lord.
I am the plaintiff in the lower court below. I have filed a money suit over there for the recovery of money suit and the interest. And
So order 9 rule 7 was rejected.
no, my lord.
There is no specific order in order 9 rule 7, my lord. Whether
All right. So now what it is, it is going ex parte.
it is
You filed your WS.
no, my lord, in the it is a case under section under order 37, my lord, the money or summary proceeding case.
Summary proceedings.
No.
You are supposed to file an objection or not?
Leave to defense should be filed, my lord. No,
Leave to defense.
no liberty was given to file a leave to defense, my lord. My order 9 rule 7
You are
application.
supposed
No,
to.
no,
Yes, yes, yes.
my lord, kindly consider the order number 3, page, impugn order dated 3/8/2022, page 3. Start from in the matter, it is admitted position. Page 3 of the impugned order. The defendant after 6 months.
1 minute. You never filed any leave to defend
No
application.
opportunity was given for
What
leave to defend. My
opportunity?
lord, kindly consider, my lord. The case was filed on 18th
When was it?
February.
When was it? Yes.
The case was filed on 18th February 2021, my lord. And thereafter, my lord, case was fixed on June 2021, my lord. And they made an application for put up. And on 24th
My lord,
24th September, my lord, the case was fixed for ex parte, which will be heard on
This is the
18th
entire
November,
COVID period, no?
during the
My lord,
COVID period, my lord.
just for,
Supreme Court extended.
yes, my lord, yes,
February 2022.
yes.
My lord,
So let us start from February 2022.
My lord, just a moment, my lord. Kindly appreciate,
It's all right.
kindly appreciate one thing, my lord. In the impugn order, page 3, it appeared that in the matter, it is admitted position that the defendant appeared after 6 months from the service of someone. However, considering the decision of the Honorable Supreme Court regarding the exclusion of time for the purpose of limitation and condition of
All right,
delay,
file
it has
within-
been condoned.
Let him file within 10 days.
But my lord,
Compensate you. Take out.
my lord.
the security money, this,
What
yes,
is the amount due?
the amount is 20 lakhs, 20 lakhs,
Yes.
more than 20 lakhs, my lord.
The petition, what is the relationship between the two of you?
My lord, he is the business transaction. I am the seller, he is the purchaser, my lord.
The petitioner is aggrieved by an order dated August 3, 2022, passed by the learned judge, 12th Bench City Civil Court at Calcutta in money suit number 45 of 2021, which is the order impugned dated 3rd August.
3rd August 2022.
By the order impugned, the learned court
Security money.
why only 5 lakhs was directed?
25% of the security money, ma'am. So the total claimed amount, 22 lakhs 52,861 is the total amount, claim amount. And 25% of the claim amount has been given as security money.
What is your contention?
My lord, in this case, my lord, there is a leave to defend should be filed without any condition, my lord.
No,
All
That is-
right, take down.
no, my lord,
As per
kindly
statute,
consider
my lord,
one thing.
Order 37 rules have 3 sub-rule filed, my lord. There,
Please read what it says.
my lord, the defendant may at any time within 10 days from the service of such summons of judgment, otherwise the disclosing the such fact may be deemed to be sufficient to entitle him to defend, apply of such summon for leave and defend such suit, and the leave to defend may be granted to him unconditionally or upon such terms as may be appear to the
Upon
court.
terms, court found this term is very
My lord, and
logical.
My lord, kindly
summons
consider.
for judgment has not been served, my lord. That should be first.
My
Issue
lord,
first, my lord.
kindly consider.
Judgment for someone as per provision of this order 37 rule 3 sub rule 4, my lord. The summons for judgment should be issued first, my lord. Within 10 days, thereafter within 10 days, my lord, I will file the leave to defense, my lord.
Show me order 37.
My lord, order 37 rule 4, my lord. Rule 3 sub rule 4, my lord.
After degree.
The defendant enter an appearance, the plaintiff shall thereafter serve and defendant a summon for judgment in a form 4A, appendix B. of
Order
such
37, rule.
Rule 3 sub rule 4, my lord.
Where is the leave to
Leave to defense in sub rule 5, my lord.
this doesn't say service of summons.
My lord, judgment of kindly
The
consider. my lord.
defendant may at any time within 10 days from the service of such summons for judgment by affidavit or otherwise,
My lord,
disclosing such facts as may be deemed sufficient to entitle him to defend, apply on such summons for leave to defend.
my lord.
Then,
They first issue upon me the leave to summon for judgment, my lord.
all right.
My lord, kindly.
Let them issue the judgment of summon, my lord. Thereafter,
My
I
lord, it
will
has
file.
been.
You give a bank guarantee of 5,13,430 to the court and 20,000 cost, you will be allowed to complete. Take down.
Exactly, much obliged.
Entire proceeding was in the, during the my lord, cost portion, my lord.
Yes,
That's security
yes,
deposit,
yes.
my lord. Can
No,
condone
no.
the cost portion, my lord.
Then I will do. Then February 2022, the Supreme Court ended it
My
up
lord.
to February 2022. Where were you all this while?
Yes.
When did you file your application?
I have filed the
Long before that.
on 18th March, my lord. 18th May, my lord,
Of?
of 2023, my lord. But
Then
there is,
take down.
I have,
The revisional application is directed against an order dated August 3, 2022, passed by the learned judge, 13th Bench, City Civil Court at Calcutta. By the order impugned, the learned court below what was your prayer?
my prayer in order 30, order 9 rule 7, my lord.
Not prayer for each other. During the pendency of an application under Order 9, Rule 7 of the Code of Civil Procedure, directed the defendant to deposit rupees 5,13,430 in court. Upon deciding that, not during the pending scene, upon deciding that 1.5 years had passed from the date of institution of the suit and no decision could be arrived at. At such juncture, the defendant appeared in the suit and filed an application for setting aside the order, fixing the case for ex parte hearing. The said application was treated as an application for leave to defend, as the defendant intended to contest the suit. I'm treating it.
My lord.
However, the learned court imposed a passed a conditional order upon perusal of the documents, bills, correspondence, and tax invoices supplied by the plaintiff, thereby directing the court, defendant to deposit 25% of rupees 20,52,861. That is rupees 5,13,430. Aggrieved, this revisional application has been filed. It is contended by Mr. Bandopadhyay that the learned court ought to have passed a formal order of by recalling the order by which the suit was fixed for ex parte hearing, and the condition of payment of 25% should not have been imposed. Next paragraph. Upon perusal of the records and the order sheet, it appears that the petitioner appeared before the learned court below. In money suit ta boleshilam to number ta
45,
কোন order dated কি হয়েছিল
45, 2021.
45 of 2021 কি বললাম and 6 months after receipt of 6 months after receipt of summons, as per sub-rule 5, the defendant may at any time within 10 days from service of summons for judgment by affidavit or otherwise disclose such facts as may be deemed sufficient to entitle him to defend and apply on such summons for leave to defend the suit. The leave to defend the suit may be granted unconditionally or upon such terms and conditions as may appear to the court to be just. In this case, the application for removal of the suit from the ex parte board was filed sometime in May 2023. That is more than one.
It is filed in the month of December 2022.
December 2022. That is almost 8 months after almost 10 months after the Honorable Apex Court had extended all periods of limitation up to February 2022. The benefit of the COVID period was given to the petitioner and the delay was condoned. However, when the law provides that the court may allow leave to defend upon imposition of some reasonable condition, this court does not find any illegality in the order impugned, save and except that instead of depositing cash of rupees so and so, amount of 5 lakh something, the petitioner shall secure the said amount by way of a bank guarantee, which shall be deposited in the court below, in the learned court below. For the delay caused, the time to file the leave to defend is extended by a period of 1 month from date, provided the petitioner pays cost of rupees 20,000 to the opposite party on account as compensation for the delay which has been caused without cost. This court is of the prima facie view that the defendant could have been more diligent and sincere in proceeding before the learned court below, and the plaintiff should not suffer on account of such delay.
My lord, one thing is that kindly.
Such cost shall be paid within 10 days to bank guarantee korbe will be filed within 31st July. Our cost will be paid to the plaintiff or the learned advocate on record for the plaintiff, who shall issue a receipt. And receipt shall be issued either by the plaintiff or the learned advocate on record. As a cost of pay korbe oi 31st July er moddhe. Ar eta file korbe on the 2nd of August. Extended up to August 2.
My lord, one thing that
At liberty to take
my lord, one
Learned court below treated my application order 9 rule 7 as the application for leave to defend, my lord. That portion should be deleted, my lord. When lordship is
You
giving,
want to file a fresh leave to defend?
my lord.
Yes.
my lord, one
The order, as this court is allowing the petitioner to file a leave to defend, the order, portion of the order by which the learned court below directed the order application under order 9 rule 7 be treated as a leave application for leave to defend is modified.
my lord, kindly expedite the suit
The suit shall be expedited and
within time frame.
within a period
Within 6 months.
within December, preferably within December 30th, 2023.
Much obliged.
This court has not gone into the merits. Expeditious.
16 and 17 are the same matters.
Same order, same date.
But the amount are different. The amount are different, sir.
A suit number is different, my lord.
And suit number. Yes.
Kom takata hocche secure. Bank guarantee. Yes.
Madam, my lord, the code number should be 12 in the lower code below.
Ageta 13 chilo, 12. Oglo we will check. It is written in your cause title.
Yes, yes.
So we'll check that. Our lasted order date is same.
The order date is same.
August.
Only suit number is
Yes,
different.
next 17.
It's 15, 16 and 17.
17 also same.
Same.
All right, 19.
Okay.
হ্যাঁ ওটা নিয়ে পড়ে এটা এগুলো নিয়ে এই দুটো নিয়ে নি তাহলে 110 what is fixed at 110?
No, there was a personal appearance with respect to Milord.
Yes. 1 minute, I have fixed a matter at 110.
This matter.
Reference কটার সময়? Gathering at 1:55. Yes, all right.
My lord, my client has present as per your lordship's direction, item number 31.
Yes, Mr. Kormokar.
Lord,
Proceedings are there. Let him stand in
yes,
front
Lord,
of
I have also called my client also.
Yes.
Lord, she has identified, Lord, this is the person, Lord, who is giving evidence on the dock. And Lord, I say, Lord, this is not Gopal Chakraborty, Lord, whose photograph I had made over to your lordship on the last occasion. Your lordship can compare, Lord, that photograph with him. And Lord, I'm also told Mr. Chakraborty, Lord, is outside the.
Who is Mr. Chakraborty?
Gopal Chakraborty.
Right.
Lord, I am told, my lord, he is not Gopal Chakraborty.
Well, how will the read court decide this? You tell
Lord,
me.
that's exactly why I'm before your lordship in 227. That's why I wanted a videography of the evidence to be recorded so that I can say that the person who is claiming to be Gopal Chakraborty on the dock
So
is
what
not
did
the
you
person.
you say? Continue with that.
Lord, if
As per learned court's direction, voter card and Aadhaar
Nothing
card was
matches.
produced before the learned court. And,
nothing matches.
and here in this case, prayed for comparison of the handwriting.
Only
My lord,
opportunity. If
kindly
that
see
goes, it goes forever.
the written statement,
That's why
sign
Lord,
of the
I
written
will not
statement
get
and
but
written
wait for
objection.
biometric.
Tell me one thing. Videography of him will be done. He will say, I'm Gopal Kormokar. How does it help
But
you?
then I will have an evidence in the appeal court that this was not the person. Kindly sees the picture. I
But
will be in a
how will the
position to
appeal court-
compare.
Who will dig out actual
The
Gopal?
evidence goes. The evidence goes.
You have to prove.
Yes.
That is
That
exactly.
is your allegation.
That is exactly what I will do until and unless I can show the person who is standing on the dock is a different person. I'm in a position to show and prove. But I won't be
How
able
will
to.
you show it?
Not by videography, the evidence of the picture.
My lord, 1 minute, my lord, kindly excuse me. The
Where is your Vakalatnama?
এই ফাইলিং নাম্বারটা তো দিয়েছে সেদিন আনেননি the other day I furnished the
Not here.
yes
You
no
have
no
not
no
furnished
in
it
the
here.
department
আনিয়েছিলে? বলেছিলাম তো আনাতে।
yes
কোথায়?
on 26th of June
Huh?
23
Order?
on that day we have supplied the number কি দেয়নি
থেকে আনানো
just
হয়। ঠিক আছে, ছেড়ে
my
দাও।
lord চাইলেন আমি তো
It's all right, all right. But there is a huge difference in the
my lord we cannot a person
take down.
a person
But how does your client bring this in court?
Not by videography. That's the only way out.
Say that. Why is she
এই ফটোগ্রাফ গুলো
Say, এটা কি photograph?
আপনার আমি জজকে দেখার পর আপনি দেখেন দেখে নিন
কোভিড পিরিয়ডে সে দেখেছে
কোভিড
হ্যাঁ।
পিরিয়ড এরকম চেঞ্জ হয়ে গেছে লোকে।
কোভিড পিরিয়ডে দাঁড়িয়ে রেখেছে
But with age, people change.
Might be,
হ্যাঁ,
Lord,
কোভিড
but this is a recent photograph that I've given, Lord.
একটু দেখে নিন দেখেন
No, that
and মানে kindly see one moment মানে paragraph
I will direct the court to verify the handwriting.
মানে
Lord, kindly directs biometrics. That's the only way out.
Who's biometric?
Lord, the person's Aadhaar card consists of a biometric. He will just go and check the biometric. That's the only way we can
No,
find it.
where will the court get the machine?
Lord, the expert is there.
my lord 1 minute দাঁড়া
It's
One
always
minute.
empaneled.
my lord kindly see the
Why are they shying
What
away?
is your suit
no
for?
we are not signing
1 minute.
মানে he is saying in that way
Say,
yes
I will have
all
the
right
ultimate say.
all right
So why are you bothered about what
no
you
no
say?
no
My suit
I
is for
should
a
not.
portion of encroachment. Suit
So
for
how does
permanent
it matter
injunction.
whether it one real Gopal, that Gopal, this Gopal, how is it important?
The person who is giving evidence could have been said that that person is a different person. I have the authority to depose on behalf of original Gopal Chakraborty. That's one case. Here, a different person is coming and saying that I am Gopal Chakraborty, who is not.
How is your client so sanguine that he is not? What is the basis? What is
Yes.
the foundation?
The basis
Just
is
because you think so, it
the
cannot
basis
be.
is he is my neighbor. I know him. That's the first basis. The second is the photographs I have. The
She's not
photographs
staying here.
which I had, Milord,
She's not
provided to
staying
your lordship on the
don't talk
Lord, the photographs that furnished on the last occasion, Milord, also apparently does not match with him. That's a recent photograph also.
And what does the client stay?
Lord, she stays. আপনি কোথায় থাকেন? Lord Krishna, Keshtapur, Lord Keshtapure.
আচ্ছা আমাকে ডেটা এন্ট্রি অপারেটর
This is the photograph again, Milord.
কেউ আছে এখানে এই লাইভ স্ট্রিমিং যে হচ্ছে ওনাকে দেখা যাচ্ছে যে ভদ্রলোক এসছেন পার্সোনাল অ্যাপিয়ারেন্স তাকে দেখা যাচ্ছে
এটা বন্ধ
ওটা চলছে
এটা বন্ধ আছে
ইউটিউবে দেখো তো ওনাকে দেখা যাচ্ছে কিনা লেট হিম কাম ইন ফ্রন্ট ফ্রম দিস রেকর্ডিং ইট উইল বি ইয়েস প্লিজ অ্যাপিয়ার দেখা যাচ্ছে তো অলরাইট the worry of the petitioner is put at rest because the
মানে kindly excuse me
claiming
1 minute
Gopal Chakraborty is present in court
yes
whose appearance has been recorded by this court and whose appearance is available in the YouTube, which in the digital platform of namely YouTube, where the live streaming of this court is being recorded. Hence, for all future reference and with regard to all allegations made by the petitioner, the lines may be placed on this live streaming before any court. Yes, disposed of.
No, only I was praying for if the
One minute, my lord, 1 minute.
The pairs of biometrics
Order
is not allowed on the ground that apart from the presumption of the petitioner that Gopal Chakraborty, who has appeared before the court and who is adducing evidence as a defendant, is not the same as the Gopal Chakraborty against whom the suit has been filed. Yes.
1 minute.
The fact that the person who has appeared before this court claims to be Gopal Chakraborty through his learned advocate will amount to a statement on oath before the High Court.
Yes.
And Gopal Chakraborty shall be bound by such statement before every other forum.
Right. What are the?
Yes.
That was produced before the learned court.
All right.
Or the second paragraph of the impugned order.
Modified to the above extent. Yes, next matter.
That dispute was soluted earlier. Can you?
All right.
Second line.
Waste time,
Yes.
please. All right.
Yes.
19.
I'm deeply.
What are the expeditious nothing বসো item 19 আছে কেউ নেই 20 ও 19 টা কি 19 20 21 একসঙ্গে what is this দেখি দাও তো শয়তানির মামলা এগুলো তাহলে expeditious disposal ডাকো not today থাক এই মামলাটা একটা উপরের ফাইলটা দাও তাহলে বুঝবো expeditious disposal ডাকতে থাকো মুখ খোলো তুমি থাক not today করে রেখে দাও দেখা যাবে ও আর আসবে না yes next call the expeditious disposal তাড়াতাড়ি ডাকো আমাকে উঠতে হবে তো সবগুলো বার করতে থাকো
This is my application.
yes what is this
Only the petitioner filed a suit for declaration.
What is the stage what are the applications pending
No matter it is up to matter the PW1 has been completed.
The petitioners are the plaintiffs entitled suit number 158 of 2006 pending before the learned civil judge junior division at Bonga district 24 Parganas North. If they can stop the petitioner press for expeditious disposal of the title suit. It is submitted that the suit is at the stage of evidence. It is also stated that no other applications are pending. Next paragraph, the prayer of the petitioner appears to be prima facie reasonable. No, considering the age of the suit, the submission of the petitioner is found to be prima facie reasonable. Within 6 months from the next date fixed. Next.
My lord, my application, my lord, appeal was filed, my lord, in 2020 against an order rejecting my application under order 21. Order 21, rule 99, 100, 101, my lord, is pending since 2020. It's not been.
Any appeal pending?
That is appeal, my lord. Misappeal, my lord.
The petitioner pressed for expeditious disposal of misappeal number 91 of 2020, which is pending disposal before the learned pending before the learned additional district judge, fast track first court at Howrah, allegedly for the past 2 years. The petitioner is the appellant before the learned lower appellate court. Considering the age of the misappeal, this court is of the view that the said any applications
No,
pending?
no, no. Written
the said
objection, they
appeal
have to
should be
file. They have not yet filed. My lord will kindly.
disposed of upon granting one last chance to the opposite party to file their written objections, opposite parties to file their written objections, if any. ওইসব করে দিয়ে within
Within
3
a period.
months. 3 months from the next date
Grateful,
fixed.
grateful.
My lord, my suit, Supreme Court by an order of 21st of 17th March 21, page 52, directed the suit to be disposed of by 9 months. I filed an application for amendment that is still being heard, my lord. The amendment application written objections are complete. More than 10 hearings have happened since
The
my lord, the Supreme
petitioner
Court order.
pays for early disposal of the application for amendment of
And
the
the suit, my lord, and the suit.
complaint, as also the suit which is pending before the learned civil judge, senior division, first court at Alipur, comma, being title suit number 1189 of 2018. It is contended that the Honorable Apex Court had directed the suit to be disposed of within 8 months, 9 months from the date of the order passed by their lordships. Yes. Without this court is of the view that the prayer is reasonable. The application for amendment which is pending along with the objection shall be disposed of within 3 months from the next date fixed. Thereafter, the suit shall be concluded within 6 months following disposal of the amendment application. Yes, next. ওইগুলো merit ফেরিট সব দিবেন upon giving adequate opportunity to the opposite parties to contest. একটা থাকলে একজন opposite party or parties দেখে দেয়। ওইগুলো এই দুটো কিন্তু থাকবেই। Yes, next.
56, my lord, after the last date of hearing on the 7th, the matter has been disposed of.
I know.
I'm obliged, my lord. Infructuous.
The revision application has become infructuous as the prayer of the petitioner as the grievance of the petitioner has been met. Disposed of without any orders. Yes. Next.
My lord, 57, my lord, my ejectment suit pending before the small causes court, my lord, since April 2022, my lord.
7.72.
7% disposed of, my lord. Cross-examination commenced in April 2022, thereafter
The
repeated.
petitioner is the plaintiff in title suit number. In
Ejectment suit number.
In ejectment suit number 6834 of 2014, which is pending before the learned 6th bench presidency the learned judge, 6th bench presidency small causes court. It is submitted that the suit is at the stage of evidence and cross-examination commenced of whom?
PW1.
Of PW1 commenced in sometime in 2020. Considering the age of the suit and considering the fact that the suit is also at an advanced stage, the prayer of the petitioner for expeditious disposal is reasonable. Tarpore ja ache tai 6 months from the next date fixed.
Great.
Yes, next.
Cross-examination 2021.
21. Cross-examination 21. So, since long, legal. Of the PW1 is going on since long.
Grateful.
Yes. Auto delay mushkil. Next.
My lord, 58, my lord, ejectment suit of 2000. La. Ejectment suit of 2012, my lord. My lord, 7172 disposed of in 2019.
Yes,
There-
petitioner is the plaintiff in ejectment.
One
suit number
application
12 of
pending, my lord.
2012, which is pending before the learned judge, second court, second bench, learned city civil court at Calcutta. Learned judge, second bench, city civil court at Calcutta. It is submitted that
That application,
applications under
amendment
7.1 and
application
7.2 of the Code of Civil of the West Bengal Premises Tenancy Act 1997
has been disposed of in
was disposed of sometime in
27 February 2022. Thereafter, SLP file not
22.
proceeded. 2020.
2020.
Thereafter, the SLP file not proceeded any further, my lord. Or Order 6, Rule 17 pending since long.
At your instance.
At my instance.
It is submitted that an application under Order 6, Rule 17 for amendment of the plaint is pending. The same is yet to be disposed of. তারপরে ওই application dispose of করবে 3 months from the next date fixed upon affording opportunity to the defendant to file a written objection to the same. Thereafter, based on the outcome of the said application, the suit shall be disposed of within 6 months.
Great.
Yes.
38.
Lordship, the defendant number 10 and 11 is the petitioner before your lordship. the plaintiff filed a suit for partition lordship. We have appeared and they have obtained an order of status quo regarding nature, character, and possession. Lordship, I have filed one application for allowing us to make construction and another application that the suit should be dismissed.
Take down.
These applications
Dismiss
are
কেন? Why?
because lordship, there is also another prior partition suit between the same
ঠিক আছে।
parties, same everything.
Dismissal of the suit under 151 চেয়েছিস? আচ্ছা, ঠিক আছে।
Let be hard
The
out.
petitioner submits that an application filed under section 151 of the Code of Civil Procedure dated September 30, 2021
This is for allowing me to construct.
for leave to construct on the suit property and another application dated September 3, 2022 are pending before the learned Civil Judge Senior Division Second Court Rampurhat District Birbhum. Such applications were filed in connection with title suit number 19 of 2020. The petitioner prays that the said applications be disposed of expeditiously. Considering the age of the applications, objections filed.
They are not filing lordship. Last chances are giving from March 2023.
And the fact that several chances have been given to the opposite party,
1 to 3.
parties 1, 2, 3.
They are the
Others are not
plaintiffs.
contesting.
They are not
To
appearing.
file written objection to the said pending application, to the pending applications. No such objections have been filed. তারপরে যা থাকবে সব দিয়ে reasonable.
Today is the date in the court below.
Within 3 months, applications within 3 months from the next date fixed, and thereafter the suit shall proceed expeditiously and be concluded within a year. Next. Upon allowing them after last opportunity to contest the application by filing proper objections. One last opportunity. Yes,
My lord,
60.
title appeal, my lord, 108 of 2019. My lord, next date of hearing for hearing of the appeal.
The appellant in title appeal number 108 of 2019, which is pending before the learned additional district judge first court at Howrah.
Yes, my lord.
Anything pending?
No, my lord, no application is pending.
The petitioner submits that the what is the stage of the appeal?
My lord, hearing of the appeal, my lord.
That the
My lord,
appeal is ready for hearing.
Yes, my lord.
But
22nd August. Next date
and
of
the
hearing.
next date has been fixed on August 22, 2019. Further contention is that the
22nd August 2023. 22nd August 2023.
further contention is that the appeal is otherwise ready for why was it not taken up?
My lord, there, my lord, time to time, my lord, actually, my lord, suit was decreed in my favor. 2016 suit for eviction. My
One
lord,
minute, 1 minute.
my lord, I am for the plaintiff. Thereafter, my lord, defendant preferred appeal. Now, my lord, suit was decreed in my favor. My lord, that my lord was stayed, my lord, by appeal court, my lord. Thereafter, my lord,
On condition, the imposed condition is otherwise ready for hearing. A further contention দিতে হবে না. Date has been fixed on 22nd August 2019 করে 1 year. Yes,
my lord, from the lordship kindly
8 months from the next date fixed. Yes. চলো হয়েছে? রাখো।
The liberty, my lord, prefer leave to file.
10:30. We have to take it.
I apologize.
কোথায়? Where is your
It is ready, my lord.
leave to file without
Leave to-
certified copy?
No, this leave to file, my lord, on power of attorney, which has come from Ireland. Now the department says that since it is written that contents not verified in the notarial certification, they will not take the filing.
Notarized from the UK?
It is from Ireland, yes, from Dublin.
Yes, allow.
my lord, petitioner is the defendant, my lord, in my case, not appellant, my lord. In the appeal.
You are not the appellant in the appeal.
No, my lord, I am the defendant, my lord. I am the plaintiff and my lord, defendant and petitioner. Plaintiff in the suit, defendant in the appeal.
The petitioner prays, who is the respondent in the appeal?
Appeal, yes.
Lordship, leave.